If you spend any amount of time on social media reacting to other people's posts, creating content, noting observations, you should be paying attention to this podcast. Social media is a landmine field of liabilities, of legal liabilities you ought to pay attention to. If you spend any amount of time on social media reacting to other people's posts, creating content, noting observations, you should be paying attention to this podcast, and you're in the right place. My name is Cash, and you're on iChat Law. We all love our social media. It is how we share our lives, our thoughts, our jokes, even our side hustles. But here's the thing. Social media isn't a law-free zone. This is the legal feed, and we are breaking down the rules and some of the things you should watch out within the legal digital world that might cause some problems for you down the range. Let's start with defamation. Well, defamation occurs when a false statement of fact published to a third party that causes harm to the subject's reputation. The fact that this is happening online, particularly when the alleged action goes viral on these digital platforms, this tends to aggravate the situation for whoever is making their claim. You may recall in the recent legal drama between Johnny Depp, yes, the pirate, Johnny Depp, and his estranged partner, Miss Heard. Well, in that particular case, Depp versus Heard trial is a primary case study on defamation in the digital age, while the case itself was multifaceted. Social media played a crucial role with public opinion shaped by viral clips and testimony heard and shared online. So the jury in this particular case heard that Miss Heard defamed Mr. Johnny Depp in 2018 op-ed, which was framed by the court as being about domestic violence allegations, and its subsequent motion on social media awarding Mr. Depp over $10 million in damages, and later there was some kind of settlement that was had on that. This case here highlights one very important point. Be careful what you say and how you say it about people who have a lot to lose and people who would fight back. In this particular case, Johnny Depp wins defamation easily against Miss Amber. And the key takeaway in my opinion is your online statements, even alluded to in an op-ed, shared on Twitter, are actionable, okay? Not only on Twitter, but shared on any social media platform. The court of public opinion on social media does not dictate the outcome of a court of law. So pay attention to that. This is very, 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 very important. Now, let's look at another issue that can really easily trap you. Customer reviews, right? This is something that happens more often than not. And most people don't even particularly think it could cause them any problems. But consumers generally have a right to leave honest reviews. However, statements must be opinion or based on provable facts. Okay, so this is very important. In a recent case, DS Development versus Perez, a homeowner was sued for $750,000 over a Yelp review that accused the builder of fraud and shoddy workmanship. The typical, right? The case highlighted the strategic use of SLAPPs. SLAPPs are strategic lawsuits against public participation. Anyway, to silence critics, right? While the case was eventually settled. This particular case demonstrated the financial and emotional cost in responding to and defending clearly what was defensible, right? It is important though that if you're making a comment and if you're posting a review about a particular experience you have with a business, just make sure that these are things you can prove. Okay, don't go be saying things or will be difficult for you to prove that could lead you into some legal challenges. And the most important part of this is that even if you can defend yourself, remember you have to defend yourself in order to be able to establish that you're right. And in doing so, that can cost a lot of money. So the takeaway again from me is frame your criticisms around your very verifiable experience. Okay, the plumbing leaked after they installed it, rather than unprovable accusations of criminal activities. Say, for example, when you say these guys are con artists, that could land you into a lot of trouble. Okay, so far we've talked about defamation, and we have also discussed the dangers around leaving a review, consumer and customer reviews. The next point I want to talk about is a big one. It happens a lot. Copyright all over the place, right? Most people don't realize they're infringing on copyright until they are sort of, caught in breaching whatever copyrights they may have been accused of, right? And the most important part is knowing what the rules are and understanding who owns what and how that property ought to be used in any type of your online experience, media interaction or engagement. That will be fair, but you ought to pay attention to this. Okay, copyrights protects original works fixed in a tangible medium, and platforms are legally required to address infringement, period. Okay, there's an interesting case involving the dancing baby. I believe the case is Lens. Is it Lens versus Universal Music? Yes, that's the case. Lens versus Universal Music Corp, which is a landmark case. Stephanie Lenz posted a 29-second home video of her toddler dancing to Prince "Let's Go Crazy." Universal Music was not happy about it, so they issued what was in the States referred to as DMCA takedown. By the way, DMC stands for Digital Millennium Copyrights Act. The Canadian equivalent to the US DMCA is Canada's Notice and Notice Regime, which was implemented as part of the Copyright Modernization Act of 2012. Unlike the DMCA's notice and takedown system, there are some unique differences with the Canadian equivalent, which the Canadian equivalent requires internet service providers, ISPs, to remove infringing content. Canada's notice and notice regime requires ISPs to notify the alleged infringer that a copyright complaint has been filed and to retain records of this notification. And in any case, Lenz sued, arguing that Universal did not consider fair use. Just remember that word, fair use. Fair use, which allows for limited use for purposes like criticisms or parody before sending a notice. The case established clearly that copyright holders must also consider fair use before issuing a takedown, or in the Canadian equivalent of that, the Canadian notice and notice regime. That brings us to my number four. Number four, how to protect your content. How to fight content theft with DMCA. And the Digital Millennium Copyrights Act provides a process for creators to request the removal of their stolen work from online platforms. This isn't just for for big companies. It's for small content creators too. When a prominent travel photographer has their image reposted without credit or payment by a major brand, they literally were given they made a claim and got the court to issue a takedown, which effectively protected their work, and that is one of the ways and examples that the DMCA, or the Canadian equivalent of that, which is the Canadian Notice and Notice Regime, can be used effectively to protect your online content. Takeaway on this particular point is that your original work is automatically copyrighted. The Canadian Notice and Notice Regime, or the DMCA, gives you a powerful self-service tool to enforce your right against infringements by major platforms or big companies. And that is something you should pay attention to. If you're still with us and you're following, and I hope you're getting some value out of this, consider subscribing and hitting the notification bell so that when our next and exciting updates on these subject matter come up, you'll be the first to know. All right, number 5, caught on camera. The law of recording and posting others. It may seem so obvious in terms of what is allowed and what is not allowed, right? And for most people, I think the shock comes when you realize that when you're in public and somebody's taking photographs, they can definitely take a photograph of you. But the nuance is in how it is used, how that particular information is used. The right to record in public is generally protected, but the right to publish that recording is governed by privacy laws. Reasonable expectation of privacy is the key in this particular instance. The viral trends of posting videos of public confrontations, for example, those fight clips, BB, barbecue, Becky, permit party, often involves individuals who may be acting badly, but not necessarily breaking the law in public. However, publishing their privately identifiable information like their home address to encourage harassment is illegal and can lead to charges of harassment. You may have a right to film in public, but you have no right to use that footage to orchestrate a harassment campaign against the targeted individuals involved. Publishing private information is a dangerous line to cross. Do not do it. Okay? This brings me to our next point, number 6, revenge porn. The severe laws against non-consensual image sharing. I sort of have a bit of a challenge with understanding why people even indulge in this type of behavior. Revenge porn is normal. It's often about power and control, not just revenge. It's about power and control. In Canada, the leading case, or the most interesting recent case, was a case in a Saskatchewan court of King's Bench. Judge awarded a landmark $160,000 in damages to a plaintiff in a revenge porn case, marking the largest sum ever granted in Canada till date for such an offense. The defendant, Dylan Hedel, had previously pleaded guilty to criminal charges for uploading explicit images and videos of his ex-partner, along with her personal details, to numerous pornographic websites between 2015 and 2019, In a civil suit, the judge found that Hadel's actions were intentional, harmful, causing the victim severe and lasting mental distress, constant anxiety and fear, which justified the substantial amount of money that was ordered in the penalty phase of this matter. Only to just say that apart from just the criminal behavior in sharing intimate photos of people that you know or may have shared information with you, it's the moral bankruptcy that this type of behavior demonstrates. Just awful. Anyway, don't do it. If you're in a situation where you think that is going to give you some credit or that is going to make you feel better, don't do it. What is the takeaway from this? This is a serious federal and provincial crime. Period. No cap. Perpetrators face severe penalties that can also include decades in prison and being registered as a sex offender. You don't want that on your record. You don't. Anyway, that brings me to number 7. Number 7, from DMs to courtroom evidence, when online harassment becomes a crime. I paused a little bit because this is one of those areas where people tend to ignore all the logical common sense stuff, right? Cyber harassment becomes criminal when it involves true threats, stalking, or incitement to violence. Period. Pay attention to this because, there are no any other better way to say this. The Michelle Carter case, referred to as the texting suicide case, is an extreme but very clear example of this particular issue. Through text messages and social media, Carter encouraged her boyfriend, Conrad Roy, to take his own life. The court found her words constituted involuntary manslaughter under the principle that her persistent instructions created a virtual presence at the time of the crime. She was sentenced to 15 months in jail. So those text messages where you're calling people names and blah, 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 and saying meaningful things, can get you into trouble. And if you have any doubt, Commonwealth versus Michelle Carter, clearly demonstrate that. The takeaway is that digital words are not abstract. They are real evidence of intent and action. You can be held criminally responsible for coercing or instructing someone to harm themselves or others. Those words are not empty threats. Okay. Next on the list of things to pay attention to is how social media can cost your job. You are fired. You are fired because of social media. Let's get the context here. In the US, for example, most employment is at will, meaning you can be fired at any reason, but for any reason that isn't illegal, right? And same thing in Canada, you can be fired for cause. So this includes your off-duty conduct online, right? I believe one of the famous cases in this particular instance is Justine Sarko's case. Before I fly to South Africa, she tweeted a racist joke to her few hundred followers while she was in the air. The tweet went viral. By the time she landed, she was a global pariah and had been fired from her PR job. The court of public opinion directly resulted in termination. The firing was, came as a shock, I think, to her because she didn't believe that her actions could be used and she could be held responsible for such hate speech and racist utterance. And the point is that be careful what you put out there on social media if you're working for an employer who has some sensitivity issues, right? So if you work in a children's If you work in an organization that support and help children, don't be putting adult messages and social media status updates that would cause your employer to be concerned. But if you're a teacher and you're posting pornographic type of pictures on social media, you're going to get fired. And there's very few instances where the law is going to be protecting your ass, literally. So what's the takeaway from this? There is no clear line between your personal and professional life online. Let me say that again. No clear line between your personal and professional life online, right? Employers will act to protect their brand's reputation from the fallout of an employee's public post. So this brings us to number 9. And number 9 is about the FTC's rules on influencers and people who advertise that you must know. For example, the Federal Trade Commission, that's stateside, mandates that any material connection between an influencer and a brand must be clearly and conspicuously disclosed. In other words, if somebody's sponsoring you, somebody's paying money to say something about their product, you must make that known. This means that if you are being paid, getting free products, or have any business or family relationship with the brand, you must disclose it stateside. The Canadian equivalent is similar. You must disclose any connection you have with people that are promoting or paying you to promote their products in a way that is a transparency in terms of the product and the claims that are being made online. Obviously, if they're asking you to say something particular and you don't like it, you ought to be the person protecting your own brand by saying, no, I'm not going to do so. This brings me to number 10, and that is fake profiles. It's a real problem. The law of impersonating and catfishing people. It's been around since online community started. Creating a fake profile can violate impersonation laws, which vary by state and by province, but generally prohibit creating a false identity to harm, defraud, intimidate, or even threaten another person. They will catch you. Your digital footprint is always evidence that can be used to get hold of you and to hold you accountable. So the big takeaway on this particular point is that impersonation isn't a harmless prank. It can be a tort that's so wrong, leading to lawsuits for emotional distress, and in many states or provinces, a crime, period. If you're still with us and you find value in what we're sharing with you, please consider subscribing and hit that notification bell. And also consider sharing this with somebody who might find same value or some value in this particular episode. Thank you. And thank you for being part of iChat Law. Number 11, the subpoena for your feed, your social media feed. Social media as evidence in court is real. As a lawyer, I've come across many instances where people thought that their social media conversations and exchange, and sometimes really nasty things they say, they think it's private. It's not. A court with competent jurisdiction can easily subpoena that. I mean, modern litigation, social media is discoverable, and deleted posts can be recovered. Okay, so don't get it twisted. Deleted posts can be recovered forensically with sanctions for destruction of evidence. So if you are out there and you are in the middle of a litigation, okay, this is on the house. If you're in the middle of a litigation or in the middle of a family law dispute, Slow your roll. Stop posting unnecessarily. And definitely do not be antagonizing, threatening, or anybody, especially somebody you're in a court proceedings with, on social media, assuming that that information is going to be private. No, it won't be. Assume anything you post online will be seen by a judge, a jury, and opposing counsel. Just think about it. The more you think about it, the more you can easily understand and control your impulses to just go on social media and let loose. Your digital footprint is a permanent searchable record that can make or break a legal case. Do not forget that. Okay? This is absolutely important. All right. So we're coming to the final but definitely not the least of the things you should pay attention to in a digital world. And that is, what happens to you when you pass? Who gets access to your social media in terms of control, in terms of feed? You see it all the time. Sometimes you go on Twitter and then you have somebody come on Twitter and say, hey, so-and-so and so passed. It was my dad, blah, blah, blah. So-and-so passed. It was my cousin, blah, blah, blah. Your digital afterlife, who controls that, right? And depending on which jurisdiction you find yourself in, there's sort of different legal tools that is available for people. With that explicit planning, your social media accounts becomes a digital ghost, right? Inaccessible to loved ones or locked according to a platform's terms of service. While Canada does not have a single federal digital afterlife law comparable to stateside, and I believe the stateside is what they refer to as the RUFADDA, but rather rather long sort of abbreviated form of that legal legal tool that is available for people who may need it, right? In Canada, we have what is referred to as the Uniform Law Conference recommendation or template, and that serves for provincial legislation as of late 2003. Saskatchewan, Prince Edward Island, New Brunswick, I believe, and Yukon have all enacted legislation based on this model act. And the act basically allows for people what to do and what service providers, platform or online, social media, online service providers can do to make the transition easier, obviously during a very difficult time in anybody's life experience. Alberta also amended its estate laws to include online account administration as an example. So it's something that you ought to pay attention to, right? So, for example, in 2016, when the Uniform Law Conference of Canada, ULCC, adopted the Uniform Access Digital Assets by Fiduciary Acts, that's the UADAFA mouthful. I'll put all of this in the link below, which provides a framework for providing framework for provinces to enact their own legislation. The goal of the UADAFA mouthful is to clarify how existing principles of fiduciary access apply to digital assets, reducing the needs for costly court orders. Obviously, if you're in everybody should, right? It's one of those things that you need to plan your estate well. You need to literally consider that as to what happens to you, and you may need to talk to your loved ones and just make sure that they know how to get access to that. Facebook, I think, is one of the few places I've seen where they've already sort of have a link called Facebook Legacy Contact, which the feature is a direct response to this particular legal tools that have been put around to help people to choose someone to manage their memorialized account after their death. So there are tools out there. Look into it if you're concerned about it and you need some clarification as to what happens in your jurisdiction. Contact a competent lawyer with enough and expertise in this matter. The takeaway here is that your digital assets require estate planning. That's easy to understand. Designate a legacy contact on your social media platform and include instructions from your digital executor in your will to ensure that your online legacy is handled according to your wish. That brings us to the end of this episode. I enjoyed having these conversations with you. We plan to have more of this type of conversation. If there's any particular subject matter or questions or comments that you want to share, please, we invite you to do so. We appreciate you being part of this platform, and I'll see you on the next one.